on the nomenclature here, which is turning out to be controversial. The issue of the tribunal. I thought there wouldn't be fuss about it, because we use these terms interchangeably, even in the courts of judicature. Mr. Chairman, it has happened even in the Supreme Court, to refer to the Supreme Court as a tribunal, to refer to a Chief Justice as an arbiter. And the Chief Justice does not take offense. And to refer to his office as an arbiter, or to refer to him as an arbiter. The Chief Justice does not take offense. The ordinary courts of law do not take offense being referred to them as. Now, I'm worried if that is going to invite disciplinary proceedings, just even if it's a mere slip of tongue, anything, that is going to invite disciplinary action. That sends chills down our spines, and it has a chilling effect on the execution of our duties. That chilling effect is so fundamental in the dispensation of justice. If I may ask, Mr. Chairman, I have had some of the officers here addressing you as your lordship. They're saying, my lord, my lord. Yet, for us, we are addressing you as a chairman. Would that also be taken to be undermining this court? That we're not addressing you as my lord? That we're addressing you as a chairman? I think the judge advocate and the entire panel shouldn't take offense about this. We can interchangeably refer to you as a court, we can interchangeably refer you as court martial or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act, and that is a different matter. So it falls within the law, under the Judicature Act, under the Constitution. That is not a court of judicature, and that is a fact. So, Mr. Chairman, I beg that you do pronounce yourself on those matters, because they are fundamental on the dispensation, in regards to the dispensation of justice.
I am mandated to advise this court. To begin with, holding this court a tribunal, that one will not happen. The UPDF Act defines court martial as field court martial, general court martial, or court martial appeal court. That is what a court martial is. Even in the Constitution, it is there that you can, the DPP can have superintendent over all proceedings apart from the court martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of Kizza as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause D. Sometimes I never to read, because when I refer to read, they say I should read. So I will read. It says every person who is, right, that's the right to a fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Elon Kizza, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here. if I may ask? Or can I say you are going to say it's a constitutional violation because a person who was convicted before this court is not there, and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no, and if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and Kizza has a specific role, to me that doesn't make sense. Maybe Counsel was saying, calling you my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even the question was asking him that he respond. There's nothing to respond there.
That if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge advocate. Why am I raising this? Otherwise, my lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. And it would appear then that the judge advocate is either coming into the realm of the state and also taking over the realm of the court.